want to tell you that if you are a young person today in Nigeria or anywhere else in a human society, you are probably already preparing for marriage, or you are seriously pondering or thinking over it, over how to get married or what a married life would be like and your prospects as a married person. If you are already married, you're already hooked, as the popular parlance would put it, then you are either enjoying the harmony and cordiality of your marriage, or your marriage has started facing a severe strain. Unfortunately, the latter is the case most of the times. In other words, many more marriages are facing strains, are facing severe crises in the world that you and I live in today. Hello, my name is Ogochukwu Onoha, and I am a human rights educator, and the channel is HumanRightsHeralds, and I am your usual anchor person, the Human Rights Wizard. And the program today is a half hour with the Human Rights Wizard. On our immediate previous video, we talked about void and voidable marriages and the differences between them and how it affects you. Today, we are discussing the dissolution of a customary marriage. In other words, marriage dissolution in the customary law, the effects. So we'll be talking about what marriage dissolution under the customary law means and the consequences. In other words, what are the results? What are the effects of the dissolution of a marriage in a customary law? If you are a layperson, possibly you are wondering, what does dissolution mean? Well, in the context of this discussion, dissolution means to dissolve or bring an end to. So we're talking about bringing an end to marriage in a customary law. Because of Nigeria's colonial experience, today we have two brands of marriages running parallel in the country. So a Nigerian can marry under the custom or marry under the statutes. In our previous videos, we talked about customary marriage and statutory marriage. We're able to distinguish between the two. But for the purpose and in the interest of those of you, my audience, who are joining this channel for the first time, I would like to distinguish between these two brands of marriages again. In Nigeria, the customary laws existed before we passed through our common colonial experience under Great Britain. And Nigeria inherited some of the British laws, which today form what we refer to as the statutes or the statutory laws. In Nigeria, the Marriage Act, an act of the Nigerian National Assembly, the Marriage Act was passed into law in 1914, but eventually inherited by Nigeria. Everything about statutory marriage is consummated or operates under the Marriage Act, and its sister act, the Matrimonial Causes Act of 1970. The purpose of the Matrimonial Causes Act is to provide for rules and steps to be taken when marriages are to be dissolved, and to provide a few other rules concerning marriages, both in the custom and in the statute. Let us go through the Matrimonial Causes Act of 1970 a little, those sections that affect what we are doing now. Section 33 of that Act of Parliament, the Matrimonial Causes Act, provides that a customary marriage can be converted to a statutory marriage. In fact, that is what happens in most indigenous societies in Nigeria, where marriage negotiations and rights begin at the customary level. We do what we call wine carrying in various parts of Nigeria, bride price payment and all that. That is the customary marriage. But the customary marriage is eventually converted into the statutory marriage when the same couple goes to the local government registry and register their marriage and are given or are issued with a marriage certificate by the federal government of Nigeria. That is statutory marriage. So a customary marriage can be converted into a statutory marriage. But Section 35 of the Matrimonial Causes Act prohibits the conversion of a statutory marriage to a customary marriage. So what this means is that the statutory marriage, the so-called white marriage, the marriage rights, or the form of marriage that we inherited through the British, is superior to the one we have in our customs. So what this implies is that the Marriage Act and the Matrimonial Causes Act both provide laws. They make rules that are superior to the ones we have in the customary law. So today, as we talk about marriage dissolution or dissolution of marriage in the customary law and the effects of such dissolution, we shall be talking, of course, about the provisions of the Matrimonial Causes Act of 1970, which affect both the customary marriage and statutory marriage. Are we ready to go? If you are interested, if I have excited you on what we have to do today, then like this video and share it so that many other people like you and I can share this knowledge, and subscribe to this channel so that you will be encouraging us to give you more of this kind of videos, and then you will be receiving my videos, our videos, firsthand, straight in your inbox. So, dissolution of marriage. In our customs, African customs in general, customary marriage, the concept of dissolution did not really exist. I am talking about marriages in the custom before our common colonial experiences. The concept of dissolution did not really exist. Marriages were to be contracted, and the partners to the marriage were to live until death separated them, until death do us part, that we now say. There were, however, very few cases that could lead to divorce in customary marriages. One was infidelity, that is promiscuity by one of the partners. The other was laziness or indolence on the part of one partner. And the other was adultery one of the partners being accused or found guilty of relating sexually with someone who is outside his or her marriage, someone who is not his partner in the marriage. And then, of course, there could be cases of insanity. Madness by one of the partners could naturally dissolve the marriage. Or the discovery that one partner suffered from a disease, a contagious disease that could potentially affect the other partner. This could also result in the dissolution of such a marriage in the custom. Then, of course, crime. One partner committing a severe crime, a crime that was a taboo in society, could also lead to divorce. Beyond these, divorces did not really exist in customary marriages, apart from such few cases. And these cases rarely occurred in African traditional societies. Now, we talk about the effects or the results of marriage dissolution under the customary law. Assume the marriage had actually been dissolved. Then what is next? What happens next? Let's take them one after the other, each one in isolation. 1. The bride would take with herself everything, every property, everything, every personal belonging that she had brought from her father's house to her husband's family. She would take them back and return to her parents. That's the first result. Number 2, that's the second result. The groom, that's the husband, would claim to have the bride price he paid on the bride refunded. He would claim and had the right in a customary law to make such a claim. So the bride price will be returned to the husband, either fully, that is either in full or in part. But there was a proviso. Sometimes there was a proviso. The bride price will not be returned in most cases if the woman already had some children for the man. The children the woman had for the man were a compensation for the bride price the man paid to marry the woman. So in the absence of children, the bride price will return either in full or in part. But if there were already children, most of the times there was no ground for a return of the bride price, but the man inherited. That is, the man inherited the right to take care of his children, and the woman returned to her parents. That's the second consequence. Now let's talk about the third, a very important consequence of divorce, whether in the customary law or in the statutory law. Custody of children, very important. Custody of children. In fact, the very fact that a divorce will result in the question of who takes custody of the children is a reason why many married couples do not want to contemplate divorce. And in many cases, many partners to the marriage arrangement have to bear situations that in a normal situation would describe as unbearable. But they have to bear it just because if they decide to move away or ask for divorce, the issue of who controls the children, who takes custody of the children will arise. So, if a customary marriage is dissolved, who takes custody of the children? I would like to begin by saying that naturally, in all cultures, the children belong to their father. So in any African culture, the man will keep custody of his children. However, the Matrimonial Causes Act of 1970 stepped in and provided some rules that no longer make it absolutely necessary that the man only can have custody of children in the case of a divorce. So going by that law, in certain circumstances, the woman can have custody. I'll give you some instances. If the children are below 7, naturally, the woman will have custody until they are of age. And when I say they are of age, I mean from the age of 7. Those children who are already 7 years remain with their father. Those who are below 7 go with their mother. And as soon as they turn 7, the woman will return the children to their father. But while the woman is with some of her children, the court provides that the man will be paying monthly alimony or weekly alimony or fortnightly alimony. Alimony is an amount of money that the court has decided that the man should be paying to his divorced wife so that she'll be able to care for the children who are with her. Alimony. And the payment of alimony will come to an end once the last child in the woman's custody has turned 7 and is returned to his or her father. Now let me add that while this is the provision of the law, sometimes what really decides who takes custody of children in the event of a divorce is the interest of the children. Sometimes, even when the children are up to 7, the court will still rule that the woman should take care of the children. After certain considerations, the court may decide that the father is not in the right position to take custody of the children. And in other cases, the court may rule that the father alone is the one who can take custody in the interest of the children. I'll give you some examples. One is capacity. It is possible that the woman lacks the capacity or capability to take custody of the children. I know some people might be wondering, how? How would the woman lack capacity? For instance, one aspect of capacity is character. If the character of the woman is one that will make her a bad role model, a bad example for her children, then the court will award custody to the man. If the woman smokes, for instance, or abuses drugs, the court can't possibly award custody of children to her. If the woman is known to be promiscuous and is one who will be bringing men that date her in and out of her house, then she will be a bad example indeed for her children, and the court will not award custody to her. What if the woman is found to be mentally unsound? It is known through a medical examination to have some mental challenge. Then it will be risky to award custody of her children to her. If all of these or one of them is in place, then the court will probably award custody to the man. And this will also happen if the man is the one that is found to lack the capacity to have custody. Then the woman will have custody. That is the provision of the law concerning custody. So the interest of the children usually overrules. But in the absence of such interest, then the law provides that children who are below 7 should stay with their mother, and those who are 7 and above should return to their father. 4. In the Islamic Maliki Code, the woman keeps custody in the event of divorce. The woman keeps custody of her sons until they reach puberty. The age of puberty could be between 12 and 14. Once the boys reach puberty, their mother returns them to their father. But custody of the girl child must be with their mother until they get married. So the girl children remain with their mother, not with their father, until they get married. The Islamic law never awards custody of girls to their father. So those are the first 4 effects. We can now talk about death. Now, if death is what has brought the marriage to an end, usually the children will remain with their father in the event of death of one or the other partner. The children will still remain with the man or with the man's family. If the man dies, for instance, in some traditional practices, in customary laws, there was the issue of ghost marriage. A man dies childless and his widow, to make sure that she remains in the man's home as his wife, the widow will arrange with the family, and she will be going out to date men and bring pregnancies home. And the children will bear the name of the late husband and inherit his estate. In other situations, what we call woman-to-woman marriage, an old lady, a woman who ends up never getting married, desiring to have children who will care for her in her old age, marries another woman and decides and keeps her and plays the role of a husband to her, apart from sexual relations. So I'm not talking about the popular gay marriages we're talking about today. No, I'm talking about African tradition. So woman-to-woman marriage had nothing to do with gay. It is not about lesbianism. The single woman who had passed the marriage age will marry a younger woman who will go out to prostitute, of course, get pregnancy and give birth, and the children answer the woman's parents' name and stay with her and look after her in her old age as her own sons. It is called woman-to-woman marriage. It is a bit different from ghost marriage. Ghost marriage means to marry for a ghost, marry for a man who is now late, so that the woman will go out, relate with men, get pregnant, give birth to children who answer the name of the dead man and inherit his estate. Now, in 1932, the West African Court of Appeal outlawed ghost marriage. It outlawed ghost marriage. It was in a case between Edet and Essien, that is, Edet versus Essien, a celebrated or popular case. The West African Court of Appeal ruled that in the African setting of 1914, that ghost marriages were no longer recognizable. it was outlawed. It was no longer according to religion. It became unlawful for anybody to marry a woman for a ghost. In 1976, in another case, Emeribe versus Akanya. In the case between Emeribe and Akanya, 1976, in Eastern Nigeria, the Eastern Nigeria High Court upheld the justice of the West African Court of Appeal in 1932. All these cases affirm that ghost marriages no longer exist. And it went on to say, that ruling went on to say that in the event that a man pays the bride price on the woman's bride price, and another man impregnates that woman, that the culture which awards custody of the child to the man who paid the bride price is against natural justice, equity, and conscience. Equity and good conscience. It is against natural justice, equity, and good conscience. In other words, a child belongs to his biological father, even if the biological father never married the woman. A child belongs to his biological father. It is necessary for us to understand this thoroughly, because today, even today, that law still exists. It has not been amended. But in many of our cultures, the custom of a man marrying a woman and inheriting a child that the woman gave birth to in her father's house still exists. It still persists in many places. That is the so-called unwanted pregnancy or pregnancy out of wedlock. A young woman gets pregnant through dating and gives birth while still with her parents. And eventually, a man from somewhere develops interest in her and decides to marry her. And the family decides, according to custom, that the bride price the man has paid covers the cost of marrying the woman and the cost of inheriting the child which the woman gave birth to out of wedlock. So the man marries the woman and adopts or inherits the woman's child as her own child and begins to play the role of a father in the life of the child. Well, this is okay, of course. This is okay so long as there is no issue. And we must understand that the law does not come to your house, to somebody's house, knocking and asking whether there is an issue here. Someone has to take an issue to the law. So there has to be a lawsuit. Someone has to sue another to court before the law will intervene. So once there is no issue, the man inherits the child along with the woman he has married. But if the father, the biological father of that child, wakes up one day and begins to say, this is my son, this is my daughter, I must take custody of my child, then the man loses the case. If the matter appears in a law court and there is a hearing on the matter, the court will award the child to his biological father. So the man who is responsible for a woman's pregnancy is the father of the woman's child. Even if the man never played any fatherly role, the woman has raised the child to whatever point in life, and one day, the man who is the biological father of that child decides to claim his child. The court will award the custody of that child to the man. So these are the issues that result from a marriage in the custom being dissolved. I hope we have enriched ourselves with knowledge today. I hope you've enjoyed our session as much as I've enjoyed your stay here with me. If that is the case, then I'll say thank you for making my day. Remember our slogan here: know your rights, protect your rights and defend your rights. In that way, we'll gradually achieve an orderly and harmonious society. And that is the aim of Human Rights Heralds, our favorite channel. I am still your humble anchor person, Ogochukwu Onoha, the Human Rights Wizard. As we bring this session to an end, I ask you once more, like and share this video and subscribe to this channel so that we can give you more of this. I want to invite you by way of closure to our next video, which is still on marriage and family life. There is still so much to be discussed on this issue. So I invite you to join me on our next video. Until then, take care of yourself, be law-abiding, and stay out of trouble. Bye-bye.